controlling your lives by controlling your banking interests. So the real question is, who do you want to be in charge? Do you want us representing the people when we go out and make our case and say, this is what we should be doing as a country, we should be doing as a state? Or do you want the bankers who meet in Davos and decide, oh, this is what we should do and this is how we're going to make the banking system work?
Thank you. Questions from the committee? Seeing none, thank you both.
Thank you very much. Have a good day.
You as well. Marty, we'll bring you up next. Good morning, welcome.
Good morning. Thank you, Mr. Chair. Marty Carlin, representing the New Hampshire Retirement System. Unlike most testimony where NH does not have a position on legislation, we don't have an official position from our board yet, but they will be voting on February 13th on a recommendation of their legislative committee, a unanimous recommendation to oppose this bill on fiduciary and plan qualification grounds. I have provided a statement to committee members. There's some additional copies on the table, and without reading it verbatim, there's some pieces I'd like to highlight here, and starting with this general principle, we've always been concerned about legislation that would mandate or prohibit specific investment actions, which could potentially limit or in some cases run counter to our fiduciary duty to act solely in the interest of our members at all times. House Senate Bill 520 creates a fiduciary definition. In outside of our statute, we do have a definition of fiduciary in 100A under Section A15, which is modeled on the Internal Revenue Code definitions of a fiduciary. Specifically, there's a lot of bullets and subletters to that, but ultimately it's the duty of an NHRS fiduciary, including its board, independent committee and investment staff, to make decisions solely in the interests of our participants and beneficiaries. In addition to the statutory provision, the New Hampshire Constitution, Part 1, Article 36A, states in part, all assets and proceeds and income therefrom of the New Hampshire retirement system, ellipses, shall be held, invested, or dispersed in trust for the exclusive purpose of providing such benefits, and shall not be encumbered for or diverted to any other purposes. So in lay terms, we have always and continue, the only goal is to make prudent long-term investments that provide the best chance of meeting our investment assumption or exceeding it while balancing risk and liquidity and other financial factors. Environmental, social, and governance, or any other non-pecuniary factor is never considered as an end unto itself. It's one of many factors that are weighed in regard to the potential impact on our ability to obtain the highest return for our members and beneficiaries. Last year, similar legislation, not exact, was introduced in the House. It was amended to a reporting requirement. It was House Bill 457. And since that took effect, we have been submitting quarterly statements to the Office of LBA, stating we are in compliance with our duty to make all investment decisions solely in the interest of our participants and beneficiaries, with no investments in funds that have mixed rather than sole interest motivations. This isn't specifically about ESG, and this isn't new. And back in the 80s, there was legislation introduced in New Hampshire to attempt to require NHTRS to adhere to what was referred to as the McBride principles, which dealt with discrimination against Catholics in Northern Ireland and divesting from companies that didn't adhere to that. And at the time, the board raised concern about that position because, based on the interpretation of the legal counsel at the time, which the NHRS agreed with, that could potentially mean that assets are no longer used for the exclusive purpose of providing benefits, but are also being used for a divergent collateral purpose of affecting social or political change. So another way of saying that is NHRS doesn't oppose this bill specifically for the contents of this bill. NHRS opposes the concept of legislative interference with what is our financial obligation, clearly stated in law and the Constitution, to act in the best interest of, solely in the best interest of our members at all times. In summary, we are concerned this legislation would serve to limit our ability as fiduciaries to do that and maintain our status as a qualified trust, which again is already clearly defined in law. Be glad to answer any questions.
Thank you, Marty. Questions from the committee? Senator Carlson.
Thank you, Mr. Chairman, and good morning, Mr. Carlin. It's a little confusing because I'm looking at the bill and beginning on line 10 through line, I would say 17, is really what I think is the crux of the bill, where it says that in making and supervising investments of the reserve fund of the public retirement system, that they will discharge its duties solely in the financial interest of the participants and beneficiaries for the exclusive purpose of. So it seems that what this bill is saying, that they're going to take all these other factors that are out there where people want to divest from certain companies for political reasons, social reasons, whatever, and say, no, you can't do that. Your responsibility is to this retirement fund. Am I reading this wrong?
No, that's accurate, and you know, in the context of that section. But our point is that is already the law, and it is already enshrined in the law and referred to in the Constitution with the sole interest of the participants and beneficiaries. So, if anything, it creates a slightly modified definition of fiduciary duty regarding do's and don'ts and things that could limit our ability to maximize our fund assets to pay benefits to our members. So, you know, so I guess it's redundant at best, and it's potentially could conflict with our fiduciary duties. You know, it's from just sort of a word search. It's model legislation from the Heritage Foundation that was introduced in at least 3 other states this year. So we don't see it as reacting or solving a New Hampshire-based issue. You know, this is just injecting New Hampshire into a wider national political debate that NHRS really wants to stay away from and just try to make as much money as we can for our members.
Thank you very much.
Further questions? Senator Altshuler.
Good morning, Mr. Chair.
Good morning.
Thank you, and thank you for taking my question. Is it the practice of the New Hampshire retirement system now to review the elimination, reduction, offset, or disclosure of greenhouse gas emissions in the entities that we invest in?
Any data for anything that the entities provide to us is reviewed, you know, in the context of, you know, is this a financially sound and stable investment for us? So yes, it's not like it's, you know, you put it aside and you don't look at one way or the other, but it's not the driving factor in any decisions. You know, it's one of many.
Further questions?
Follow up?
Follow up? Yep.
Does the New Hampshire retirement system evaluate its investments based on whether a company provides access to abortion services to their employees?
Not to my knowledge.
Okay, so follow up.
One more?
Do you read this on line 30, page 4, as if they do, we have to now, because, you know, we now have to not put them on the table, even if they are a wise investment for the taxpayers of New Hampshire and the retirement system?
That is actually a sort of a theoretical concern with some of those pieces in there, whether, you know, what's spoken to in a public hearing is the intent. An individual who has standing could challenge, you know, investing in Microsoft because Microsoft, you know, covers abortions or something like that. And that doesn't have anything to do with the financial viability of a company like Microsoft. So it's more of a theoretical concern, but any challenges like that are going to take trust fund assets and time to counter. So, we take away from the core of what we do.
Further questions?
One last question.
One last? All right, I'll
Yep.
give you one more.
So in the, we went down this road prior, and do you see this as yet another attempt to redefine what is a very well-defined term in the banking industry of fiduciary?
It contains some sections that, the Internal Revenue Code has a definition of fiduciary, and that's where we look. I know Department of Labor can issue standards and things like that, but we look at the code and try to have New Hampshire match that. There are, this obviously isn't unique to New Hampshire. This has been an issue with several states for several years. In fact, there was a House bill yesterday that AD&A voted to ITL unanimously, not the same language, but similar sentiment. So it's an issue I think it'll continue to come up. And again, honestly, NHRS isn't concerned specifically because it's ESG. It's the general concept of any kind of carving away of fiduciary duty for other, other motivations.
Thank you.
Thank you.
Further questions from the committee? Seeing none, thank you, Marty. Representative Hobson, I see you back there. Did you want to speak on this? Okay, just want to make sure. All right. Michelle Veazey from New Hampshire Business for Social Responsibility. Good morning and welcome. Please turn your mic on.
Good morning, and thank you for hearing my testimony. Again, Michelle Veazey. I'm the Executive Director of New Hampshire Businesses for Social Responsibility. We're an organization of over 240 businesses and their stakeholders in New Hampshire who work to try to maximize our financial returns with the goals of also being environmentally and socially responsible in our operations. So I won't read verbatim the letter that I have provided to you, but I'm learning. It basically covers the businesses that we work with value environmental, social, and governance factors because they feel that it actually improves their opportunities for maximizing their financial returns. We feel that the New Hampshire retirement system, their professionals, and the advisors that they use are best to implement the decisions that they have using whatever factors they feel are important to understanding how they can maximize their returns for the state employees. And so we feel that ESG is one set of tools that they can in fact use and should be allowed to use if they deem that they are important in evaluating an investment. So we encourage this committee to not get involved in trying to override what the New Hampshire retirement system does in terms of their very able review of investment opportunities, and we hope that we leave it wide open and allow them to have the tools that they need in order to make the investments. Over 90% of the Standard & Poor's 500 companies create ESG reports. So it is obviously something that is of value, not just to New Hampshire companies, but to companies all over the country and the world, and to take the evaluation of that out of the calculation, we feel is not a good use of the legislation that's before you. Thank you, and I'm happy to answer any
Appreciate your
questions.
testimony. Senator Perkins-Coie.
Thank you, Chairman, and thank you, Ms. Veazey, for being here. Isn't it true that we've seen in recent years that there can be externalities to a company's operation that have become internalized as costs. As an example, exposure for chemical manufacturers to lawsuits over eventual cancers deemed to be caused, et cetera.
That's one of the things that the factors that are included in ESG is evaluating the long-term risks that a company may face because of factors that they're not truly accounting for within their current financial returns. So they may have very good short-term returns on investment, but when you look at the risk that they're bearing for their stockholders, it sometimes can be very high because they are aware of those external costs that aren't being fully accounted for on their financial returns. So yes.
Paul, sure.
And I don't know if you've had the opportunity to review the language of the bill, but I know you just mentioned that 90% of Fortune 500 companies produce an ESG report. Do you have any opinion on whether the bill is clear if a fiduciary invested in one of those Fortune 500 companies, whether they would be following their fiduciary duty based on the language?
I think the majority of S&P 500 companies are following their fiduciary duty, but I think they value the opportunity to be able to understand the impact of environment and social issues and governance issues as well. And so I do think they're following their fiduciary duties, and I think it's important for the state to be aligned with what the IRS has defined as fiduciary responsibilities. Otherwise, it gets into a lot of modifications that have to be made in order to accommodate separate language.
Yeah, follow up.
One more?
Sure. Yeah, no, I appreciate that answer. I think I was just trying
I'm
to
sorry.
look at one other layer, which is that, there are fiduciaries acting on behalf of the New Hampshire retirement system. And I think part of our job is to make sure their duties are clear, their fiduciary duties are clear. And so the bill sort of implicates, well, you can only act on behalf of financial interests and not on any of these sort of political or social factors. But it would be hard to find a company that is not itself acting on behalf of these political and social factors. So I guess I was just asking whether you felt like the language of the bill was clear on what our New Hampshire retirement system fiduciaries need to be doing.
The language of this bill, I
Yeah.
think, takes it in a different direction than what the IRS and most companies are evaluating.
In practice, yeah. Okay, thank you very much.
Senator Altshiller, did you have a question?
No, answered.
Okay.
Thank you.
Further questions from the committee? Seeing none, thank you.
Thank you very
Appreciate you
much.
coming in.
Thank you.
Ellie Gold. Roberts. Sorry, this is the third name.
Good morning.
Good morning. Welcome.
Thank you. My name is Allie Gold Roberts. I'm the Senior Director of State Policy at Ceres. We are a nonprofit advocacy organization with over 200 members in our investor network who collectively manage $46 trillion in assets under management and 80 corporate members in our policy network called Businesses for Innovative Climate and Energy Policy. Many of these companies and investors have significant investments and interests in New Hampshire. We have strong concerns over SB 520, which would require state and local retirement system fiduciaries to only consider quote-unquote financial factors when discharging duties related to investing and proxy voting. The majority of mainstream investors, as Michelle just said, including our members, view environmental, social, and governance factors, also known as ESG, as material and consequential to the financial performance of their investments. Investors must consider all risks and opportunities to ensure their organizations remain profitable over the long term and that they fulfill their fiduciary responsibilities on behalf of their beneficiaries. Government should not dictate which considerations are allowed over the considered judgment of financial professionals, nor is it the role of government to impose restrictions on proxy voting, a critical component of our dynamic capitalist system and a key mechanism by which investors engage with companies that they own on a variety of material subjects. The purported rationale for the investment restrictions imposed by this bill is to ensure that retirement system fiduciaries discharge their duties solely in the financial interests of participants and beneficiaries. But last year, as you all know, the legislature acted with HB 457 and passed that into law, so this is really unnecessary. In addition, Governor Sununu did an executive order in April on the same subject. SB 520 serves in contradiction to these established protections by imposing restrictions on the types of factors that the fiduciaries may consider, regardless of whether those factors pose financial risks, which is their duty. In addition, the fiscal note provided by the retirement system notes concerns about the bill including potential costs due to portfolio divestments, as well as unclear definitions, which I think the senator was just getting to, misaligned authorities, and conflicting laws that would make it very difficult to administer and implement. We've seen this in other states like Indiana, Arkansas, Kansas, North Dakota, Texas, and Wyoming. And as the retirement system said, this is really a model bill that is attempting to be imposed here in New Hampshire. These losses ultimately hurt pensioners, place an undue burden on the state, and certainly is not in line with everyone's goals here. Adoption of this bill is really in the wrong direction for New Hampshire. Thanks so much.
Thank you for your testimony. Questions from the committee? Senator Perkins Coker.
Thank you, Chair. So, I mean, this is significant. You're saying the Indiana State Legislative Commission released a fiscal analysis projecting a $6.7 billion decrease to pension fund returns as a result of a similar bill. How do they document that, just sort of performance before the legislation and performance after?
They ended up modifying the bill after that study came out and a new study was put forward, but the original bill language, they were concerned that it would limit the retirement system's ability to access certain well-performing stocks that we know would have been kind of eliminated as a result of the definitions.
Okay, thank you.
Yeah,
Further questions? Seeing none, thank you.
thank you.
That's all I have on the list. Anybody else that would like to testify on Senate Bill 520? Seeing none, we will close the hearing. Yeah, please. Thank you.
Yeah.
Okay. I did see him earlier. Oh, he is there. Oh, there he is.
Yeah.
Nice seat in here.
Good morning, Senator Fenton.
Good morning.
So, now with the prime sponsors here, we will open the hearing on Senate Bill 368. I will recognize Senator Fenton.
Thank you so much. Good morning, Mr. Chair and members of the committee. For the record, I am Senator Donovan Fenton. I represent District 10. I am introducing Senate Bill 368 relative to service retirement allowances for teachers and other Group 1 retirement system members. This bill will make a correction to the long overdue law passed in HB 2 that updated when Group 1 teacher and employee pensions are recalculated to a lower rate. This updated that age from 65 years old to one's full Social Security age. However, as part of the New Hampshire retirement system's interpretation of this law being prospective from the effective date, the New Hampshire retirement system read the law to mean that it only applied to people who had not yet retired, even if they had not yet reached their full Social Security age. This bill would fix that by capturing the fixed group left out by the New Hampshire retirement system's interpretation. We believe this will better capture the intent of what the legislature meant to achieve, and that's it. I'll take any
Thank you, Senator.
questions.
Questions from the committee? Seeing none? Appreciate you coming in.
Thank you guys so much.
Marty, I think we'll bring you up next. Welcome again.
Thank you again, Mr. Chair. Marty Carlin representing NHRS, which does not have a position on this legislation as it's a policy matter. I did sign up to kind of walk through a little bit of the background, just so you're clear on what you're doing and who's affected. Last year, I think this committee recommended out a Senate Bill 57, which was an adjustment to the service retirement formula and recalculation for Group 1 employee and teacher members that ended up in House Bill 2. And what that did was it changed the law at the time, which stated that a Group 1 member's pension is statutorily recalculated when they turn 65. It's a slightly different formula, and it results in a reduction of about 10% in the member's benefit, a little bit under 10%. So that was a remnant, that was not a remnant, it was included in changes back in the 80s which prior to that, your Group 1 benefits were offset by how much Social Security you were getting. And that offset, it was a very complicated formula, but it could be anywhere from 10 to 40%. So back in 88, 89, the legislature delinked Social Security and NHRS benefits, but it did keep this a reduction in, the law said, age 65. Since at the time, the federal government had already amended the Social Security Act to have account for higher retirement ages, but the people who were affected by that were in their 20s and 30s when the legislature made the change back in the 80s, and now they're aging and they're retiring and they're aging into it. So the last year was one of in a string of multiple attempts over the last few years to change the language in our statute to index the benefit recalculation to the member's attainment of full Social Security age, under federal law, which for anybody born 1960 and after is age 67 now. So that was passed in House Bill 2, signed into law by the governor, effective July 1 of 23. So typically, I think it's not just NHRS, but any statutory reading is the law is prospective unless otherwise indicated. So our reading was anybody who retires on or after the effective date of the bill. That's the formula for them because that's the formula they're retiring under. Anybody who retired prior retired under the previous formula, so that would be a retroactive application. So this bill this year would explicitly state that anybody who hasn't turned 65 by the effective date of Senate Bill 368 wouldn't see that reduction until their full Social Security age. So, the effect is about, the actuary said there's around 3,000 retirees, who have not yet turned 65 and haven't been subject to the recalculation. So they would get that somewhat slightly larger benefit for a couple more years, until they age after they turn 67. So it's a retroactive application, but it's not a permanent benefit change that would increase their benefit for life. It's basically, giving them that extra, giving them the more favorable formula for a couple more years. There is an unfunded liability cost associated with that of about $11 million. That would be paid off in a 20-year layer, amortization layer through employer contribution rates, unless there was an appropriation to pay it up front. The change last year in House Bill 2 did include a $44 million appropriation to pay that off, the unfunded portion of the change that affected more members, it affected future generations. It was, larger in scope because it's all Group 1 members going forward. So that's basically the lay of the land on this bill, and be glad to answer any questions.
Thank you, Marty. I guess I have one right away. Did you say there was about 3,000 retirees that we affected? Did I get that right? Okay.
Yeah.
Just wanted to confirm that. Thank you. Questions from the committee? I think you got off easy, Marty. Thank you. Dennis Martino. You signed up in favor, and welcome.
Thank you. I am a retired state employee, and this change doesn't affect me at all because I'm a real antique. And I started my career after college. My first job was as a public school teacher. So I see some of my NEA colleagues back here. I went from being a public school teacher to being a state employee, and I am the president of the State Employees Association retired chapter. And so we've taken a look at this. The State Employees Association has taken a look at this. I was asked by Rich Gullo, who's the president of the State Employees Association, who's apparently I think he's in Washington and couldn't be here today. He asked me if I would come and speak to the issue. And we're we are on the side of this change, and that was put together by a group of senators, obviously, sponsoring this legislation. When I read it, I look at it as restoring something to people who are in the system. And the idea behind it was not how much is being paid, but who's doing the paying. So we looked at this legislation as in a very favorable light, and we hope that you do, or we're asking you to. So it looked to us as the change being a favorable one, and restoring, going back to a system that was, a shared cost. Employees in the system pay into it. The employers in the system pay into it. And this seemed this change originally looked at it as the employees were still paying into it. The employers were paying a little bit less. And it's about, I want to say, a tenth of what the cost was. So I don't know if you have any questions, but we wanted to go on record as being in favor of this bill as it was written.
Thank you, sir. Questions from the committee? Looks like we're good. Thank you.
Thank you so much.
Tracy, I'm sorry, I don't want to butcher your last name. I can't quite read it. I'll let you tell us.
My name is Tracy Bricky.
Ricky, all right, there we go. I got it now.
Thanks. And I am newly elected president-elect, that sounds weird, of the New Hampshire Retired Educators Association.
Congratulations, I think.
Yeah, me too. This is my first time testifying, so if I make any missteps, please bear with me and make sure you tell me. I was a public school educator for 35 years. I taught high school math and physics, and then I became administrator up through assistant super. My organization, New Hampshire Retired Educators Association, is not just a retired teacher association, it is for all retired educators. I retired from education in 2018, and I am currently serving on the Merrimack Valley School District School Board. So I understand the implications to employers. We, as a group, the New Hampshire Retired Educators Association, are urging you to please consider this favorably. I will turn 65 this year. My full retirement age is 66 in 10 months. So I, as an individual, consider myself kind of a poster child for this bill. So last year's bill was a great start. I see this, we see this as kind of a mind the gap kind of thing, where that gap that I don't consider it sort of retroactive, just kind of filling in what was missed in the original language, or in the original interpretation of the language, I guess is a better way to say that. Again, I would urge you to consider this favorably, please.
Thank you. You did just fine.
Thanks.
Questions from the committee?
Thank you.
Well, thank you. I'm sure we'll see you again.
Probably.
Karen.
Good
Good morning and welcome.
Good morning. This way or that way? Good morning. Thank you, Chairman Pearl, members of the committee, for hearing this piece of legislation, letting us testify. My name is Karen Irwin. For the record, I'm from Hopkinton, New Hampshire. I'm a Group 1 state retiree, and I am an individual that got captured in this because I retired before July 1, 2023. So as of now, the history on it, I've got quite a history because I testified in support, and I want to thank the legislature for their great support of Senate Bill 57 that went into House Bill 2, which corrected the misalignment for most of us are at 67 now, or 66 in 10 months, or whatever, 66, in that gap that got adjusted down by about 10%. They call it a 10% adjustment. This allows it to not happen for 2 years for most people. The prior person would be, 2 months short of 2 years. So anyhow, in my particular example, I had 39 years in the retirement system when I retired, and I retired August 15th in 2022, and when I turn 65 right now, I still will get a reduction of 10%. That affects me by $469 a month for 24 months. So that's a reduction. When we first retire, we all put in 7% of our account when we're employed. It goes into our own personal accounts. Those personal accounts move into the corpus of the fund when we retire. But those are still funds that are ours, essentially, in that if we were to die suddenly before we use up all the funds come out of our accounts theoretically first. So all those payments that have been made for me have come out of my individual fund balance. So should I be in a fatal crash or something, knock on some wood now, but there would still be some money that would go to my children from that fund. So you're kind of allowing us to not take the 10% hit, because it takes 5 to 6 years for me to use up all the money I've got in that account, theoretically. And we've put into it for years. It was always the intention of the pension system to match Social Security retirement age, which used to be 65. Full retirement age was 65. And it hasn't aligned since 1988. So it's been a long time coming to get where we did. And thank you again for the support of the bulk of the employees. And I hope that you will join me in support of this bill. Just to take it one step further, just to explain what kind of impact it could have to people if they had to take, because they had to pay their bills, not only would they take a hit at 65 when they can't get full Social Security to 67 if they were like me. And in my personal case, if I had to take Social Security at 65, I would get an additional hit to my household of another $377 just to illustrate, how deep this hit could go. So that would be, $846 a month for me if it was in that situation where I had to take care of a parent or something, or my husband. I want you to recognize that we've had some really good returns. NHRS last year's report said they had an 8.2% return on investments for the fiscal year, which was very good considering how investments were going last year. So they've been doing very well. This bill is only a fiscal note it affects 3,000 people, which is a lot, and it's a lot, but it's not a lot of money for the benefit it provides. So it was purely an interpretation. I think it just had to be effective on that date, and it wouldn't have been retroactive for those that had already retired. So it could have gone into effect. And the language of Senate Bill 57 never really eliminated anybody out of that loop. So the definition of members for the retirement system was that retiree members weren't in the members definition. It was. So I'm hoping that we can correct this because it was recognized as it was going through the process of getting into the budget, but it was too far into the process to do anything about it, do another fiscal note amendment or anything like that. So, you know, if this bill does not pass, I will, and 3,000 others will, our 10% will go down, where if you had retired after July 1, 2023, you don't have that anymore. So it is the right thing to do. I hope you support this. It really does not significantly detract from meeting any obligations or the impact the unfunded liability, really. $520,000 a year.
Thank you, Karen, for your testimony. Questions from the committee? Seeing
Thank
none,
you.
Thanks for coming in. Our final speaker is Brian Hawkins from NEA New Hampshire. Good morning and welcome.
Good morning, Mr. Chairman, and I do have some written testimony with me. I will say everyone before me did a terrific job, and so they've I don't have much more to add. I would just emphasize a couple of things. First, we would like to reiterate our appreciation for the legislature's taking action with Senate Bill 57 and the inclusion into the budget. As you know, this was a recommendation made by the 2017 Decennial Commission, and so we appreciate the commitment of the Senate following through on that. Senate Bill 368 represents an attempt to correct, as I think what was called this gap group, who had retired prior to July 1 but had not yet reached age 65. I think it's important the way this bill was worded. We believe that it still maintains that prospective nature of what the legislature intended while capturing this group of retirees who, a couple of whom spoke earlier. And the legislature originally enacted the law out of fairness to those who at age 65 no longer had their pensions partially offset by full Social Security benefits. And so we hope this committee sees fit to fill in that gap for those fixed group of retirees, and that you find Senate Bill 368 ought to pass. I think everything else is captured in my written testimony, or President Tuttle's written testimony.
Thank you, Brian.
Yep.
Questions from the committee? Seeing none?
Okay, thank you very much.
Marty, can I ask you to come back for 1 sec? I do have one question for you. Thank you. I appreciate you coming back. So last year, you testified that we put $44 million in, we funded Senate Bill 57. When we did that, did we anticipate these 3,000 members being funded in that $44 million?
I don't recall that this coming up. You know, I'd have to look back at our handouts, but I think, you know, we had said we read it as prospective. So this, you know, this came up after the fact when some folks called and said, hey, well, you know, the law changed on July 1, so that's when the people retiring on or after that are affected. So the 11 million didn't come up. I don't recall any discussions in either committee in the Senate about that cohort of people.
So I guess my question is, would this 11 million already be covered in our cost estimate of the 44 million last year? Or would
This adds that population to the population that the 44 million, you know, funded the liability on. So it's a plus, not it's not already part of that.
All right, I agree with you. I don't recall us discussing, and the thought never crossed my mind that we weren't covering all of the people.
Yeah.
And at the time, that's why I was curious about the number, but thank you. I appreciate it.
Thanks.
Anybody else that would like to testify on Senate Bill 368? Seeing none, I'm going to close the hearing. And Senator Susie is here, right? Yes, she is back there. And with the prime sponsor being here, we will open up Senate Bill 309 and recognize Senator Susie to introduce. Good morning. Welcome to EDNA.
Good morning. Thank you very much, Mr. Chairman, members of the committee. For the record, I'm Donna Susie. I represent Senate District 18, and I am here to present Senate Bill 309 FN. You might note that the sponsorship of this bill is a bit leadership heavy, and I'd like to explain the genesis of it. As you recall, last year during the budget cycle, there was much discussion around retirement issues, particularly Group 2. And we didn't reach a final resolution, so as a result, a study committee was created that I served on, as did Senator Bradley, Senator Gray, Senator Waters, and many of our House colleagues as well. There was a great deal of work and discussion done during that study committee. Obviously, a lot of it focused on Group 2, but there was a lot of discussion about Group 1 as well and looking at the benefits. So one of the results of this committee's work was a proposal to change the vesting period, which is currently at 10 years, down to 5. That was unanimously adopted by the commission. There was a great deal of discussion about workforce shortage, and that was part of what drove the issue. It was believed that this change, which is rather insignificant in terms of dollars, but is significant to the individuals that it potentially impacted, was believed to be an important change to help retain employees. One of the problems the state and many of our political subdivisions are facing is that people come into the job, they're possibly thinking about a pension, but it seems too far off and they end up leaving for more money in the shorter term because they don't see the likelihood of attaining the benefit and it being as meaningful. So it was the view of the entire committee that by changing the vesting period to 5 years, it would assist with retention. And as you look, and possibly recruitment as well, and as you look at the fiscal note, you will see that the impact obviously has no impact on the current biennium that we're in for rates, because rates have already been set. It would be going forward. And I'm sure, since Mr. Carlin has already testified, that to the extent there are more questions about the fiscal note, might be best to hear from him directly, but I'm certainly happy to answer any questions. I should also note that the reason I'm the prime sponsor is that the chair of the study committee, Representative McGuire, designated me to be the prime sponsor, and that's accurately documented in the report. So, second page.
Well,
So here I am on behalf of all of my colleagues who spent the summer working on retirement.
Well, thank you for spending your summer, and thanks for introducing the bill. Questions from the committee? Seeing none, thank you.
Thank you very much, Mr. Chairman. Thank you.
Marty, we'll bring you up again. You're becoming a staple of our committee today. And Marty, if you would, in your testimony, just for my benefit and the others of the committee, just explain what the investment, being vested means.
Sure thing, Senator Pearl, thank you. Again, Marty Carlin, representing the New Hampshire Retirement System. NHRS doesn't have a position on this bill, as it is a policy matter. So when we talk about vesting in an NHRS world, that means when you become vested, you've earned the right to a future benefit. It doesn't immediately grant you a benefit. It does, it basically you've crossed a line where you are eligible when you meet other, age or other service requirements. So, so for instance, someone, right now vesting is 10 years. So if somebody is, 22, they come out of college, they're a teacher for 10 years, they're vested with 10 years when they're in their early 30s, but they're many years away from retirement. But they've got that flag in the sand that they're vested. So even if they terminate employment and move out of state, do something else, if they kept their contributions with us, once they age into eligibility, they can collect a benefit based on the period of service and the salary they earned. Obviously, in that situation, that somebody be collecting a benefit 30 years later, there's no, there's probably with inflation, it's not a huge benefit, but they'd be getting a benefit. So they know that there's a guaranteed lifetime benefit available. There are certain other benefits contained in our statute that you need to be, to have 10 years of service to qualify. It says 10 years, it doesn't say vested, but this bill changes that to 5. For instance, non-job related disability, so nothing to do with your work. That's 10 years right now. If somebody had less than 10 years and fell off their roof or something and couldn't work, they wouldn't be eligible for an NHRS benefit. Vested deferred retirement, those are the folks who leave before retirement age. Non-job related death benefits. So all of those would move to a 5-year. So the vesting would impact both eligibility for service retirement and for those other benefits. So, this is, I'll stop there and say, does that answer your question?
Yes.
Yeah, okay,
Thank you.
great. And as Senator Susie testified, this was a recommendation of the Retirement Benefits Commission, and she shortchanged their work. It was all summer and all fall. They were meeting. So the fiscal analysis of this bill, it would obviously, because more people than otherwise expected under current law would be eligible for a benefit, i.e. those who work more than 5, less than 10 years, there is a long-term cost associated with this. Try not to use adjectives like nominal or small or large because that's in the eye of the beholder. But as a percentage of the employer rate for these groups, it is a small percentage. For instance, the employer rate for teachers is about 19.6% of payroll right now, and this would add 0.03% of pay additionally. So, I mean, it's still money coming from the employers, but as a proportion to what's being currently paid, percentage-wise, it is nominal. The most expensive increase, which is 0.17% of pay, is in the employee group. And just sort of an interesting reason for that is that group, folks entering the employee group in New Hampshire on average are significantly older than people entering the other group. And if you think about it, there's a logic to that in the sense that people go to school or, train to become teachers, police officers, or firefighters. So generally speaking, not in all cases, you're starting that job as a younger person, whereas a employee position, you could have worked in the private sector for 20 years and took a job or this and that. So they're automatically coming in closer to retirement. So that's, just sort of a fun fact, case the question comes up on that. Because we wanted to give some context on what our vesting period is versus other states, on the flip side of the handout we provided, the National Association of State Retirement Administrators, NASRA, puts out and then updates, every 12 to 18 months, charts on what other systems are doing, what their assumed rates of return are, et cetera. And one of their reports deals with vesting periods. So NHRS is one of 25 out of 105 statewide retirement plans that have 10-year vesting. 5-year vesting is 60 plans, or 57% have that. So, we're not outside the range, but we're at the top end of the range with 10-year vesting. That's always been the case, and our statute is 10-year. Other New England states, Maine and Vermont, are 5. Mass, Rhode Island, and Connecticut, for folks hired after 2011, are 10. So just purely for context, to make that available and let you know. And based on the conversation on the prior bill, Senate Bill 368, I do want to put it out there that we read this bill as prospective as well. So any Anybody who's in the system right now who has more than 5 and less than 9 years would become vested if this were to pass. But we don't see it affecting somebody who worked from, 2008 to 2013, still have their funds with us. So if the intent is to include those former employees, we would recommend a mandatory sentence to make that more clear. If comfortable with the prospective, then that wouldn't be necessary. Obviously, if you add that cohort of folks, it would increase the cost to some extent. It's a finite set of people in that range.
Marty, you read my mind. I was going to ask you that question.
We tried.
Eliminated one.
Yeah. And just again, it's a little more in the weeds, but I think there may be a question about it. So what happens when somebody does terminate right now, whether they have 10 or more years or less than 10 years? So if they, for whatever reason, they are no longer an active contributing member, they have options with their accumulated contributions. The money that they put in, it's their money, so they can take a lump sum out, withdrawal that terminates their relationship with NHRS, and if, depending on their age, there's some tax considerations for that. They can take that sum and roll it over into another qualified plan, and defer the taxes until they can collect on that, or they can leave it with us. The member interest for active and inactives is set by statute, so it can't be less than 0 in any calendar year. So you can't lose money. There's a cap on how much you can get in uncredited interest, which is currently 4.75%. But for people who don't need the money, think they're going to come back to public employment, for different reasons, people can leave their money with us. So those are the 3 options people have, and it's not a decision they have to make at termination. They could leave it for a year and then take it out in a year, or leave it for 10 years, so that's how that works. And that's all the members' money plus the interest. The employer contributions go straight into the general trust and pay all benefits. So there's no match that a terminated employee has a right to from the employer side.
Thank you. Questions from the committee? You answered mine already. Seeing none, thank you.
Thank you.
Bob Fuller. Good morning, welcome to ED&A.
Good morning. Good morning. Thank you for allowing me the opportunity to speak. My name is Bob Fuller. I'm a social studies teacher who works at Mason Memorial High School, and I've done so for the last 27 years. Also, I was a NEA New Hampshire appointed member of the Retirement Commission, which has been already referenced, and I was the person that brought this to the commission. And I just wanted to speak on that today, and again, I appreciate your time hearing me out. A lot of what I was going to say has already been covered by Senator Soucy and Mr. Carlin, which is, again, they brought up a lot of good points. But just a little bit of background behind this, if I could just add a couple points to you. A lot of the things that we bring up in the committee were around attention and retraction, retraction and retention of state workers, whether it be police, fire, teachers, and other government workers. And one of the things that we were looking at, and that's why the reason why it was brought up in terms of looking at making some fixes in terms of the retirement system, and the parts of, again, keeping workers have already been done, so I won't do that again. One thing with teachers in particular, for instance, is I find, for instance, that a lot of teachers are entering the career as a second career. So therefore, also looking at it from attracting people, the 10-year period for them would be a really long time. So if they're entering the field at, say, 50, for instance, or 55, then they're really not going to be able to get to that sort of retirement age. But then, if, for instance, we can now take them, for instance, they already have a lifetime of experience and they want to serve. So if we can now get them into the classroom and actually have an end date where they can actually also, pay into the system and also get something out of it, that would be a great benefit to them, be a great benefit to the system, it would be a great benefit to the kids that now have these people in the classroom that are so experienced, and that these are people that I work with and they do a really good job. So that's a point. Also, too, one thing that was already brought up was just looking at bringing us in more aligned with other states. So because the fact of the matter is, and I would look at the New England states in particular, because if we're going to be losing qualified workers, whether it be police, fire, teachers, or whatever else, to other places, they would be more likely moving to states that are around us. And if we bring our rules in line with them, just from a competition standpoint, and if we're able to then retain those workers and also attract new talent, that's going to be a benefit. And it's going to be also a benefit to the residents of New Hampshire. It's going to be a benefit to the taxpayers. Because the fact of the matter is that we're also able to now spread this out a long period, just from a fiduciary standpoint, it also becomes very prudent. Because the fact of the matter is that the cost becomes a lot smaller. And also just from that point, it becomes a lot easier to be able to manage that cost. One also point I would like to bring up is just the cost to attract and actually train new workers. Because the fact of the matter is that employers, whether it be public or non-public, they spend thousands of dollars every single year attracting and then training new workers. So then if we're able to also keep the ones that we have, it has a double benefit. So then we're not paying out those new costs. We're also able to keep those qualified workers, and those qualified workers are then going to be providing better service to the citizens. And that's also a huge benefit. And just kind of looking also at our retirement system, you know, it does a lot of good. But the fact of the matter is that, I mean, we definitely could do a little bit better. And we were talking about a lot of things over all those months in order to be able to help that system. This one proposed bill is not going to solve all those things, but it's a really good, prudent step forward in order to make the system better. And if we make the system better for the long term, everyone's going to benefit. Thank you.
Thank you for your testimony. Questions from the committee? Senator Carson.
Thank you, and thank you for coming in today, Mr. Fuller. I just have a couple of questions, if I may, Mr. Chair. Isn't it true that teachers are tenured at 5 years?
Yes, that is true.
Okay, so do you think it would be advantageous to have them tenured and vested into the retirement system at the same time, that it's more attractive as a benefits package?
I do, yes, and thanks for bringing that up, because I think coming that in line and making those like the 5-year thing in line would make a lot of sense.
Okay,
thank you.
Thank you.
Senator Gendro, do you have a question?
Thank you, and thank you for taking my question. Just out of curiosity, do we have a handle on how many older people are making teaching their second career?
I don't have numbers for you right now, but just from what I'm seeing with just 27 years in the classroom, in recent years, it's definitely going up. And the thing is, I think it could be going up even more if we make it more attractive to them, because even within the last, I'd say, 3 years, I've noticed a really huge uptick in people coming in, because a lot of times they're coming in now uncertified, so now they're working through programs to make themselves certified within like a 3-year period. And we have someone in the district that actually works with them and actually makes sure that they can actually get all those qualifications. And there's been dozens and dozens more that I've just seen in Manchester over the last, I'd say, 3 years. I can't speak for the entire state, but in Manchester, of course, that's the largest city with the largest school system. I've definitely seen it going up, and I think something like this can make it go up even more.
Okay.
Follow-up?
Yeah, follow-up. So of those that have come in, is the retention there as well, or are they running out of the classroom saying, I can't do this?
I can't speak if the retention is, I would say just the retention's an issue really across the board. I hate to bring up COVID again. We've talked about COVID so much, but the fact of the matter is that the classroom is a different place coming back into it. And we're having a really across the board a hard time retaining teachers. And it's not just a New Hampshire problem. It's not a Manchester problem. It's not a New Hampshire problem. It's a national issue. So from that standpoint, just with our retention issues that we're having, and just because for no one's fault, just the job's changed. It's changed for teachers. It's changed for really all public servants. And I really think that anything that we can do to help attract and retrain new people would really, really help.
Thank you.
Further questions from the committee? Seeing none, thanks for coming in today.
Thank you very much.
John McAllister. Good morning, welcome.
Good morning, Mr. Chair and the honorable members of the committee. For the record, my name is John McAllister. I currently am a 25-year member of the Nashville Fire Department, and I currently serve as the Secretary Treasurer for the Professional Firefighters of New Hampshire. The Professional Firefighters of New Hampshire is an association that represents over 2,000 active and retired firefighters within the state of New Hampshire. I'm here before you today to testify in support of Senate Bill 309. This legislation would simply lower the years of service needed to be considered vested within the New Hampshire retirement system from 10 years to 5. A concept that came out of a recent committee to study and discuss potential changes to the current retirement system with unanimous bipartisan support. We have been in front of you this committee numerous times before talking about retention and recruitment within the New Hampshire Fire Service. This specific bill would maintain and recruit and retain members just by simply lowering that number from 10 years to 5. Currently, Maine and Vermont consider vesting at 5 years of service. New Hampshire, it would take a firefighter double that time to be considered vested, and to know that he or she is able to attain benefits that were promised to them when they were hired. As someone who's been in the fire service for over 25 years, I've seen my fair share of changes within the New Hampshire retirement system. Shortly after I first came on, they eliminated the medical subsidy for any members that were hired after 2001. But those members who were vested in the system or already hired were able to obtain and continue to receive that medical subsidy. And again, in 2011, we saw the sweeping effects of the changes that were made to members that were currently on the job within the state of New Hampshire, but not quite vested. So members who dedicated 9 years of their life to public safety, their benefits were changed. This bill would reduce that from happening again in the future. It has been common practice here in New Hampshire that once a member is vested, that their benefits cannot be decreased. This legislation maintains that principle and achieves a sense of security that an employee from the New Hampshire retirement system deserves. I strongly support Senate Bill 309 and urge the honorable members of this committee to do so as well. I have submitted written testimony and would be happy to answer any questions from the committee that the committee may have. Thank you again for your time and consideration today.
Thank you for your testimony. Questions from the committee? Seeing none, thank you.
Thank you.
Kathy Stacy. Good morning, welcome.
Good morning, Mr. Chair, members of the committee. My name is Kathy Stacy. I represent the New Hampshire Association of Counties. I, too, was a member of the commission that met this past year. And I'm here just to say that we support this provision. We would like to see this because especially in the field of corrections at the county level, we have significant problems attracting people, and the superintendents believe that if you have a 5-year vesting provision, that some of these younger people will look at it and say, yeah, I could stick it out for 5 years and become vested, as opposed to the 10 years, because a lot of them, 10 years seems like an eternity, because we are talking about younger people who are entering that field. And so they believe this is something that they can add in their toolbox and think that it will attract people, and we would like you to support the bill.
Thank you for your testimony. Questions from the committee? Seeing none, appreciate you coming in. That's all I have on my sheet. Anybody else that would like to speak on Senate Bill 309? Seeing none, I will close the hearing. All right, we will open up the hearing on Senate Bill 482, and I will recognize the prime sponsor, Senator Carson.
Good morning, Mr. Chairman, and good morning, fellow ED&A committee members. For the record, my name is Sharon Carson, and I have the pleasure of representing Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And I have for your consideration this morning Senate Bill 482, relative to National Guard and staff judge advocate access to criminal history records. I brought this bill forward at the request of the New Hampshire National Guard, and this proposed legislation provides statutory authority to the New Hampshire National Guard military attorneys to access confidential criminal history records, criminal investigation documentation, and public court records of current National Guard personnel. This proposed legislation would provide these attorneys with the same access that local, county, and state prosecutors have. There's currently no New Hampshire statute that provides the National Guard military attorneys with the authority to obtain confidential criminal history records or criminal investigation documentation. As such, they have obtained drastically different responses to record requests from state and local law enforcement agencies. The range of responsibility has varied widely from a full release of an investigative case file to denial, because the law enforcement agency treats the request as a right to know request. Under the latter, the National Guard attorney has been previously advised that no information would be released unless authorization is obtained by both the alleged offender and the victim. The proposed legislation would enable the National Guard to take appropriate security measures and, when appropriate, take necessary administrative actions against soldiers and employees based upon the information collected through criminal investigations. Because the potential actions may not have that may have been taken are not judicial in nature, the due process rights within the New Hampshire criminal justice system of National Guard employees and service members would not be affected by this legislation. And finally, Mr. Chairman, the proposed legislation does not provide access to the police records of a New Hampshire citizen who is not a New Hampshire National Guard employee or service member. I'm going to conclude my testimony at this point, and the National Guard folks are here to answer any questions you might have.
Thank you, Senator.
Thank you very much,
Any questions
Mr.
from the
Chair.
committee? I see none. So, General Michaelitis, do you both want to come up? I see you've got two signed up. All right, come on up together. So we have General Michaelitis and Captain Otis, is that correct?
Sir.
All right, I'm sorry.
Mr. Chair, committee members, for the record, I'm David Michaelitis, the Adjutant General for the New Hampshire National Guard, and I'm joined by Captain Ryan Ollis, one of our military attorneys. And in his former life, when he was a part-time military attorney, he was a county prosecutor. So I think he has the lens that he can answer any specific questions that you may have of this. In addition, we've given you two pieces of paper, testimony from both myself and Captain Ollis, to the specifics of this bill. We also want to thank Senator Carson on our behalf for sponsoring this bill. A bottom line up front, we are a standards-based organization, and this is about good order and discipline in our force. So in the unfortunate event that inappropriate behavior occurs off duty by one of our service members, we do not have access to those criminal records. So, for example, driving under the influence, domestic violence, anything of that nature, which a local county state prosecutor has access to. Senator Carson nailed it. Some jurisdictions have a right to know policy, so we cannot get access to that information. This establishes parity with our military attorneys, with our, like I said, municipal, county, and state prosecutors to just give us similar access. So if appropriate disciplinary action has to occur within our formations, we can take it. No more, no less. Subject to the questions, that's all I have.
Thank you for your testimony. Questions from the committee? Senator Altshuler.
Thank you. Thank you for being here. Thank you for your service. I'm curious, does this also give reciprocity to the county attorneys when there is something that has happened in the context of National Guard service that would be of, interest to a county attorney.
Turn it off.
Yeah, turn the red is on. There you go, you got it.
Red means go. For the record, this is Captain Ryan Allis, Associate General Counsel for the New Hampshire National Guard. We already provide documentation at the request of any police department or county attorney's office. We get the request in writing and respond in kind.
Further questions from the committee? I guess, so you've never been able, it blows my mind that you've never been able to access any criminal records prior to this?
Mr. Chair, I think it just varies by jurisdiction. So, for example, I think Captain Allis can attest to that. Like, one jurisdiction may say, "Hey, here you go." Another jurisdiction may say, "Hey, sorry, it's a right to know, so we cannot share that information." So it's just parity. It's just given attorneys talk to attorneys. We get the information. So if something happens on the outside, we're aware of it, and then we can take the appropriate actions.
I guess every now and then we get a bill in front of us that we go, really? I didn't realize you couldn't do that. So, well, thank you. I thank you, Senator Carson, for bringing this, because I didn't realize that was even a concern. Further questions from the committee? Anything further you'd like to add?
And no, sir, thank you for your support.
Absolutely. Well, thank you. Appreciate your testimony. Thank you for your service. Kevin Grady.
Thank you, Mr. Chairman. Ladies of the committee, for the record, my name is Kevin Grady. I'm a 25-year Air Force veteran, and I'm also a 25-year veteran of living in the town of Hooksett, New Hampshire. Today I'm representing the 20-member organizations of the State Veterans Advisory Committee, and our 20 veteran support organizations unanimously do support this bill. I always like to follow General Michaelitis because he answers 99% of the questions that you might have of me. But I want to just give you just an anecdote from my time in the service that may put some perspective on this. And I had a couple of my charges that were arrested for smoking marijuana off base. And I didn't find out about that for months, because they didn't have that kind of working relationship, and the folks on base didn't really have the right to go down and ask him that question. The way I found out was that a federal agency called me and said, "I think that you ought to suspend these guys' security clearance because of this marijuana conviction." And I went, "What marijuana conviction?" So that flow of information is really important, because as the general said, you know, there's no such thing. We're not going to do double jeopardy. If you're tried for an offense in the civilian courts, the military is not going to try you for that offense. But we can take administrative or non-judicial action. These two people were packing my parachute, okay? I don't want people that are smoking marijuana before they come to work, and these guys were ultimately caught again on a drug screening. I don't want those folks packing my parachute. I'm sorry, maybe you feel differently, but I don't. So we need to have that knowledge. And there might be times when, as the general has said, an offense, especially if we look at marijuana laws and things like that, where they're changing in states near us, okay, the local people might not do anything about that. But we, in the military, that's still a UCMJ offense, and we would want to know that. And even if we weren't going to take court-martial action, at least we could take non-judicial punishment or administrative action for that. That's really all I wanted to leave you with. The general did a good job of saying why I think we need this bill.
Thank you for your testimony. Questions from the committee? Senator Carson.
Thank you, Mr. Grady. I just want to thank you for bringing up the issue of the security clearance. Most people in the civilian world don't understand how important a security clearance is. And if something happens on the outside, meaning off base, that involves civilian police, oftentimes, and you're correctly saying, you're not going to know unless you're notified. And something like that can and should affect a security clearance, because as you know, people sometimes deal with very, very sensitive information. And you folks really need to have this information so you can make judgment. So again, I want to thank you for bringing up that point.
Yes, sir.
Further questions? Seeing none, we thank you.
Thank you.
Anybody else that would like to testify on Senate Bill 482? Seeing none, we'll close the hearing. Good morning. We will open up the hearing on Senate Bill 481 and recognize Senator Perkins Quokka, the prime sponsor. I can't speak today, sorry.
No worries. Thank you, Chair, and thank you, members of the committee. For the record, I am Senator Rebecca Perkins Quokka, represent District 21, which is Portsmouth and the surrounding towns. I'm here today to introduce SB 481, an act relative to establishing Juneteenth, June 19th, as a state holiday. As tomorrow, February 1st, marks the first day of Black History Month, this is the perfect time to be talking about this bill. June 19th, often referred to as Juneteenth, has a deep and rich history in our country. This day is celebrated annually by a vast amount of people across the country to commemorate the official end to slavery in the United States. It is a day when our country turned a page and a day worth honoring. In 2019, New Hampshire took an important step in acknowledging Juneteenth as an annual observance. What this bill would do is make Juneteenth a state-recognized holiday to correspond to the federal holiday. Growing up in Stratham, I certainly remember there being other conversations around our state about recognizing other holidays, and I'm really hoping we can work together to put Juneteenth into a proper status for its significance. Many states across the country have done this. All 50 states observe or have this holiday. And notably, it was elevated to a federal holiday in 2021. SB 481 acknowledges the history of our country's past. It is time for Juneteenth to be recognized as the same legal status as Martin Luther King Jr. Civil Rights Day, Washington's birthday, Labor Day, and many other holidays that commemorate the different aspects that went into forming our country and our state. With that, I'm happy to take any questions.
Thank you for your testimony. Questions from the committee? Senator Carson.
Thank you, Mr. Chairman. I thought we did this already. I remember a few years ago, Senator LeVake, when she was here, I thought we declared that it was a holiday. Maybe we didn't do it right?
Right. I thought we had to. And so when the state offices were open last year, I actually asked the question about this. And so it is a federal holiday. It is not a state holiday. It was just an observance.
Okay.
So just hoping to correct that.
Thank you.
So to make sure I'm understanding correctly.
Yes, sir.
If we do this, we're adding it as a paid state holiday, is that correct?
Correct.
And offices would be closed?
And offices would be
closed. Okay, just want to make sure I understood. Thank you.
Yes.
Further questions from the committee? Seeing none, thank you. Is there anybody else that would like to testify on the bill? Seeing none, we'll close the hearing on Senate Bill 481.
Can we take a break, like a 5-minute break?
We can. We're going to take a 5-minute break, and then we will come back and go into executive session.
Just be glad, Senator Perkins Coker, you're not in judiciary. Just be glad.
I'm glad I'm not.
Are you an
judiciary all the
attorney?
time.
Aren't you an attorney?
All right, I will accept a motion to go into exec session.
So moved.
Do we have a second? Moved and seconded. All in favor?
Aye.
Aye. Well, I want to thank the committee for all we're doing, because I've had you on a pretty rabid schedule of hearings here. And we finally have a little time we can exec, and we have a bunch of bills to get through. So I guess we'll just start at the top. It probably makes the most sense, and I've got some that I want to hold until next week for various reasons, and as we go through, I'll let you know. All right, Senate Bill 300 I want to hold till next week, because Fire Marshal Toomey will be in, and he has some information that I think will be pertinent to the committee on the motion, so I'm going to hold that one.
And just a reminder, Chair, that I won't be here next week.
Okay. We do have a few bills we want to exec, but thank you for the reminder.
Yeah.
Probably wouldn't hurt to remind me again.
Okay.
Senate Bill 306.
Mr. Chair, I'd like to move up to pass.
Do we have a second?
Second on the amendment.
Second.
All right, and I know Senator Avard provided an amendment for the committee to consider. I'll try not to go too fast so that we can all, that's kind of why I want to go in order, because that's the way my binder is. All right, so Senator Carson is moving Senator Avard's amendment. Is there a second on that?
Yes.
And that is Amendment 0098S, seconded by Senator Perkins Quokka. Senator Avard, did you want to speak to this amendment?
Senator Avard, no, I'm not Senator.
I mean, sorry, I'm reading.
No,
Senator Carson, would you like to speak to this amendment?
I think Senator Avard's amendment makes some necessary changes. I think he listened to, I think Senator Avard's amendment addresses some of the issues that were brought up during the public hearing, and I think it's a good compromise and a way forward.
Further comments from the committee? Senator Perkins Quokka.
Yeah, I tend to agree. I know we had some concerns with reinstating the full board, so willing to see how this works, but I hope, we'll keep our ears to the ground in terms of making sure that this was the right route to go and remain open to other changes if needed.
All right, further comments? Seeing none, we'll be voting on the amendment 0098S. All those in favor say aye.
Aye.
Any opposed? And we'll be voting on the ought to pass as amended motion, including the amendment from 0098S. Any further discussion from the committee? This will be on an ought to pass as amended. All in favor?
Aye.
Aye.
Any opposed? Consent?
Move consent.
Second?
Consent is moved and seconded. All in favor?
Aye.
Any volunteers to take this one out?
I'll take it out.
I'm sorry, I didn't. Senator Perkins Quokka, okay. All right. I want to hold 309, 318.
Mr. Chairman, I'd like to move Senate Bill 318 ought to pass.
Second.
Okay, we've moved, sorry, I'm just pulling my phone here. All right, we have a motion and a second to move Senate Bill 318. Actually, since this is my bill, and if you don't mind, I'd like to speak to it. Thank you. I think this is an important step, these compacts, as we look at the work shortages that are occurring within our state. And I think this compact, and I know we've got another one coming up here, a few bills down, that I think they're just an important part of how we're going to help to hopefully get the needed bodies into the state that in these important areas where we're adopting these compacts. I anticipate you'll probably see several more over the next few years that are going to come through that will kind of respond to these work shortages that we are seeing in the state here. So I certainly would appreciate your support in hopefully we can move this forward. Senator Perkins Coker.
Yeah, thank you, Chair. Just to briefly add along the same lines, I chaired the SB 220 Mental Health Workforce Task Committee, you know, a year and a half ago, and you know, endorsement models and reciprocity across state lines for our workforce were one of the outcomes of that committee. So I think this is right in line with that.
Further comments? Seeing none, all in favor?
Aye.
Any opposed?
Move consent?
Second?
Consent's moved and seconded, all in favor?
Aye.
I'll take this one out. Next is Senate Bill 336.
Mr. Chair, I'd like to move interim study.
Second?
Interim study has been moved and seconded. Senator Carson, would you like to speak to your motion?
Mr. Chairman, I just struggle with this. I don't see how you can really enforce this. And I think that's the biggest problem. And I just see that if a public employee says the wrong thing, that there's a potential that something can happen to them. Sometimes people are not up to date on information, or they might have misunderstood that. It's making the assumption that they're saying something intentionally. And I don't think that's the case, and I just don't think it's good public policy. I think, if anything, it needs to be looked into a lot further. So at this point, Mr. Chair, I'd just like to stay with the interim study.
Further comments from the committee? Senator Altshuler.
I would like to agree with Senator Carson's assessment, particularly calling attention to Kathy Stacy's testimony. And, you know, she really boiled it down to a single line. How do you know if and how much a person has been disciplined? And also, I take exception to the assumption of this legislation that public officers or employees are frequently making fraudulent statements or materially misrepresenting members of the public. That's not true. There are people who will, but that is not reflective of the group as a whole. And I actually don't know that we need to study that any further, and think we just ought to ITL this. So let it go.
Well, the motion on the floor is interim study, so
I
that's
know.
what we'll be
I'm just
voting on.
telling you where I am.
Understood. Further comments from the committee? Seeing none, all those in favor?
Aye.
Aye.
Any opposed?
Nay.
By voting nay, we can't put this on consent. You're okay with that?
I think I have made my objections clear. I withdraw my nay and join the committee in interim study and move consent.
Consent has been moved. Is there a second? Second. All in favor?
Aye.
Aye. Senator Altshuler, would you like to take this out?
No, thank you.
I'll take it.
Senator Gendro? All right, Senate Bill 337. Senator Perkins Coker, I think, would you like to move on to pass on this?
I would. I move ought to pass on Senate Bill 337.
I will second. And
you.
I know you have an amendment you want to offer.
I do. I would like to move for the committee's consideration Amendment 2024-0275S, which you should have a copy of. It was released yesterday.
And I recognize you to speak to your amendment.
All right. Thank you very much, Chair. So I know we had some testimony at the hearing that some lactation providers were not covered by this. There's a delicate balance that needs to take place here. I think we all share the goal of making sure as many moms and babies are successful and, doing that right has a lot of different pieces to it. So we want to stick as close as possible to the original piece that was passed in SB 175 and HB 2 last year, Omnibus. And in doing that, we essentially ask that the certification will be done, by the OPLC board. And so in that way, we're not necessarily naming certain groups to be included, but rather asking that be done by the folks who are more qualified to do it. And so as far as I understand it, all the groups involved in this are on board with this amendment, and I would appreciate your support.
Well, thank you for your work on this. I know there was some concerns, and I appreciate the efforts you've put into it. Further comments from the committee? Seeing none, we'll be voting on Amendment 0275S. All those in favor, say aye.
Aye.
Any opposed? We'll be voting on ought to pass as amended using Amendment 0275S. Any further discussion from the committee? Seeing none, all in favor?
Aye.
Any opposed? Do we have a consent?
Move consent.
Second.
Consent has been moved and seconded. All in favor?
Aye.
Senator Perkins Coker, would you like to take this out?
I would love to.
I'm going to skip ahead because I see Commissioner Merrifield is here, and I had asked him to attend, and I want to be respectful of his time since I know the G&C is still in. And I want to move ahead to Senate Bill 372, and I will move interim study. I'll give you just a second to catch up because I know I threw you a curveball here. Commissioner, if you want to come up. We had asked, well, I actually have to get a second. I'm moving interim study. Do I have a second?
Second.
All right. So we have worked a lot on this bill behind the scenes because conceptually I support the idea, but we had run into some concerns about federal dollars, and Commissioner Merrifield and the director, Win Young from the U.S. Department of Labor, and I, and as well as Attorney Osterhout and Commissioner Director Courtney, we've had a couple of meetings on this, trying to figure out if there was, excuse me, a way we could do this. But Commissioner, if you want to speak a little bit to the federal concerns, I know we had asked Win Young to be here, but because of an illness, he's not, and I appreciate you stepping in and kind of filling in the pieces for the committee on this.
Certainly happy to join you. And Mr. Chairman, thank you very much for the opportunity to speak. Senators, thank you. Yes, as you mentioned, Senator Pearl, we had meetings with the Federal Office of Apprenticeship here in New Hampshire, their director, Win Young, last week. And I think the concern is that, well, let me back up just a little bit. There was a time in New Hampshire when the state, through the Department of Labor and our Apprenticeship Council, actually approved registered apprenticeships and monitored apprenticeships in the state of New Hampshire. I don't know, because it long predates my service, I don't know when this change took place, but the federal government, through the Office of Apprenticeship, has taken over that responsibility. I have correspondence between the federal government and then Commissioner Kapadas, back and forth letters determining that fact, that the Apprenticeship Council now is merely encouraging of apprenticeships, does not actually have a role in approving those. So the concern that is placed with us now with this legislation is that the one-to-one ratio that exists between plumbing apprentices and the apprentice is a federal standard of one-to-one. Some states do have a different ratio, but that is based on a federal waiver. So the difficulty for our apprentices here in New Hampshire is that those apprentice programs would not be eligible for federal support dollars. And also from the perspective of the apprentice, by not being a registered apprenticeship program, they no longer have the portability to other states, would not be able to carry those credentials to other states. And so I think there's probably more discussion. Again, I think that we'd all support for workforce reasons. We would be supportive of some kind of change in the ratio. However, these situations, these issues present.
Thank you, Commissioner. And I know we talked about the Apprenticeship New Hampshire program, about that might put those dollars in jeopardy for these young people that are trying to go through college and need that assistance with it. And, you know, the federal waiver that we talked about, I guess it sounded like to me that there's a potential that we could find a way around this and maybe not even need legislation. So for those reasons is why I thought at this point in time that interim study was probably the best path forward. And I have spoken with Senator Murphy about it, and he understands why that I have made that motion. So thank you, Commissioners. Anything further you'd like to add?
No, you restored my memory on a couple of points, so I appreciate that. Thank you.
Because I wrote notes down.
Yes, and I did not, because I thought Wynn was going to be here.
Exactly, and I do appreciate you coming on a very
Absolutely.
short notice, so thank you.
My
Any
pleasure.
questions from the committee for the Commissioner? Okay, thank you so much. I
Thank you all.
appreciate it.
Thank you, Senators all.
Further discussion from the committee? Are we ready to vote? All right, seeing none, all those in favor of interim study, say aye.
Aye.
Any opposed? And
Consent?
consent is moved and
Second.
seconded. All in favor?
Aye.
And I'll take this one out. All right, we'll get back in line here. I just have to figure out where I was.
Page
See, we did
67.
337,
367.
367. We did put 337 on consent, right?
Yes.
Yes.
Sorry, I was trying to get my notes. All right, do we have a motion on 367? Senator Carson?
I move ought to pass.
Second?
All right, we have a motion of ought to pass and a second. Discussion from the committee. Or Senator Carson, did you want to speak? I'm sorry.
Sure, I was going to call you Mr. President.
Oh, please do
Mr.
not.
Chairman, I think this bill just reinstates and continues the Commission on Post-Traumatic Stress Disorder and First Responders. They've done an incredible amount of work, and it is a working commission. They meet regularly, and I think this is an issue that we, as a state, we need to continue to work with and get information from the commission to advise us on legislation. I think they do a great job.
Further discussion from the committee? Seeing none, all those in favor of ought to pass?
Aye.
Aye.
Opposed?
Consent?
Second?
You have consent moved and seconded, all in favor?
Aye.
Volunteers to take this one out?
I will.
All right, Senator Carson. I want to hold 368, 370.
What, do you want to hold 368?
Hold on
Okay.
one second. 368 is a hold?
Yep.
I
Gotta have a file here somewhere.
That's the one we heard today.
Yeah, Mr. Chair, I'd like to
Oh,
move
it was today. That's
Yes.
why it's.
Senate Bill 370 interim study.
I will second.
Second.
Senator Carson?
I'm sorry, what are we on?
We're on SB 370.
370.
All right, I just put 368 aside. Now we're
Yeah.
370.
I'll give you a
Slow
second
down.
to catch up. I know, I'm moving
370,
quickly.
you are moving really fast.
Did Senator Pearl second
Yes.
that? Because I also heard you say second.
I did second it. Actually, I will speak to this if you don't mind.
If you do, that's fine.
So I have spoken with the Police Chiefs Association and with an individual state troopers. There were opportunities already available for these sorry, lost my terminology. Retired, thank you. I was going to say off-duty, I'm like, that's not right. For these retired officers to recertify, I recognize that there probably could be more, but my understanding is there are 7 or 8 different agencies currently that will fulfill that task. At least that's the information I was given after the hearing. And so I think there was some concerns raised about departments complying with, information about their concerns about officers being in good standing, and I just don't think right now I'm comfortable putting this liability onto them at this point, so I think interim study would be a reasonable motion.
You just said interim study?
Interim study.
Okay, thank you.
Further discussion from the committee? Seeing none, all those in favor?
Aye.
Any opposed?
Move consent.
Moved and seconded. by
Seconded.
Senator Gendro and Senator Carson. All in favor?
Aye.
Senator Gendro, would you like to take this one out?
I'd be happy to.
All right. I want to hold 371. Already done 372. Next one would be 439.
I would like to move on to pass.
Second?
You have a motion and a second? Senator Carson,
sorry.
you want to speak to your?
For 39.
This is 439.
I'm just trying to get my files.
Yep. I'll
Yeah,
let you catch up.
Just a couple of points that were made, that this bill mirrors an executive order that was adopted by the governor, making sure that there's no anti-Israeli boycott in procurement. And we have a decades-long successful exchange with the state of Israel, over $1 billion in export. So there really is no reason to discriminate, and we want to make sure that that continues.
Comments from the committee? Seeing none? All those in favor?
Aye.
Aye.
Any opposed?
Consent?
Second?
Moved and seconded. All in favor?
Aye.
Senator Altshuler, would you like to take this one up?
Well, I think Senator Carson has a
Senator Carson,
good
okay.
handle on
Yep.
it.
Okay.
All right, next will be Senate Bill 440.
40.
Sorry, I'm trying to get my paperwork in
No,
order
we
here.
all have
I
tons
know
of
we're
paperwork.
moving quickly.
Yep.
All right. I want to move on to pass on this. Do we have a second?
I will second.
And we have an amendment that Senator Ward brought in, amendment number 0067. I'd like to move that.
Okay. And I'll second the amendment.
So this bill, we had a lot of discussion on. We've had a lot of contact and correspondence on it. And I think that the feelings that, and I know there's a lot of emotion around it, and it's, I want to make sure that we understand that this is about having the availability of patients to receive these services, and we certainly have found that, had a lot of testimony that there were underserved areas within the state. I know, Senator Gendro, especially in your area, that, and I felt like we had enough testimony to convince me that the optometrists had the appropriate training in their schooling to perform these services. While I know there was concern raised by the ophthalmologists, and I don't want them to feel like that fell on a deaf ear, because I certainly listened and understood, but I feel like that this is a situation where we need to move this forward so that the citizens of our communities can have access to these services. And I know that, the concerns that are raised, I guess this bill will go to the House, and there'll be an opportunity for conversations to occur in the interim, and perhaps if there is some compromise that can be made between the two parties, they can do that prior to it getting to the House. But this would allow us to direct the board that they could allow these services to occur. They can authorize it to occur. So they'll have the oversight of the optometrist board, excuse me.
Pun intended.
Still getting
Oversight.
the oversight. No more puns, I promised. All right, I'm
You can't help it. You can't help it.
We can't get away from it, I know. So anyway, I guess that's where I have come away from in listening to all of the testimony and all of the many calls and outreach from both sides on this. And it's, I appreciate all that did it because it's really a topic that we needed to look at. So I know Senator Gendro, you had some comments you wanted to
Yeah, this is definitely a challenging bill for me. And the thing that I guess that I struggled with is to make sure patient care was there. And I shared with some folks about, I had eye cancer 22 years ago.
Oh, wow.
And my optometrist was amazing. And he told me I had primary acquired melanosis, but he was not going to touch it. He wanted to send me to an ophthalmologist, which the ophthalmologist did determine that it was an aggressive cancer in my eye. And that ophthalmologist even said, I don't feel qualified, I'm going to send you to Boston. So I had a great experience with that. Looking back now, I'm glad that my optometrist didn't attempt, or not that he couldn't have, but I think it was beyond, his scope. That's kind of the foundation that I'm going on, and I also am going to that same practice, and I also believe Erica Griffin, who's in that practice, just won in Littleton, in my district, just won a prestigious award. And I would have to say that as an optometrist, I would trust her with some of those procedures. And there's others in there that I would. So I struggled with this, and I know that the bottom line is patient care. And I would hope that the optometrists, that they've had a lot of schooling, and that they would not take on something that they did not feel qualified for. So thank you for letting me speak to this, but it definitely was a struggle for me.
Senator Perkins Cook.
Yeah, thank you, Chair. I'm inclined to agree, having listened to everything. I mean, I agree with both of the comments made so far. This was a tough one to balance, but ultimately it is an access to care issue. And I've asked a lot of questions offline and outside of the hearing because from a drafting perspective, we're being asked to vote on something that is sort of a negative, right? We're approving optometrists to move forward with something that isn't expressed here. And so to feel comfortable with that, I've asked a lot of questions. I've gotten answers to a lot of those questions. I received confirmation that optometrists, separately need to go through a process in order to have the permission to prescribe. It's a very limited prescribing scenario, and I believe that other states' experience with expanding this practice is relevant to our decision, where there have been really no incidents. And so I think the decision is properly left in the hands of the Board of Optometry, despite all that I have learned in the past 3 weeks. And so so I'm happy to join you in voting not to pass.
Further comments? I know the whole process of excluding from a prohibited practice, it made me stop and think about it. It's
Yes.
like, okay, I guess we're saying you
A
can do
little
it.
difficult, right?
All right, if we're ready, we'll be voting on the amendment 0067S. All those in favor say aye.
Aye.
Any opposed? Then we'll be voting on Senate Bill 440 ought to pass as amended with using amendment 0067S. Any further discussion from the committee? Seeing none, all in favor?
Aye.
Any opposed? Consent?
Okay, I'll move consent.
Second. Consent has been moved and seconded. All in favor?
Aye.
Aye.
Any volunteers have the vision to take this one out? Sorry.
I'll take it.
I'll laugh at a good pun any day.
Senator Gendro.
I'll be a good pupil.
Oh, no.
Okay.
Okay.
That was good. Okay, we're gonna hold 478. We're gonna hold 480 and 481. So the next will be 482.
I'm sorry, one more time. Holding 478,
80 and 81.
80 and 81.
Chair, if I may,
Yes.
just before we skip over, there was an amendment, I think, that was discussed for 480. Is anybody working on that, or should I reach out?
Yes.
Senator Carson is.
Wonderful.
Yes,
Thank you.
I was informed by Mr. Osterhaus when he was here that they are working with the Real Estate Commission
Okay.
to have a meeting of the minds, and they will have an amendment for us.
Wonderful. Thank you very much.
All right, 482.
Oh, we just
That was the one we heard today, yes.
That's the one we just heard today.
Are we doing today, bills?
Well, I only am this one because it actually makes 100%. And if the committee would like to hold it, we can, but I just thought this one, there wasn't any questions on it.
482.
I think Deb is just asking because 481.
480.
I have a question on
You
481,
have a
that's why
question.
I wanted to hold it, because I want to talk to Director Arlinghouse. Or Commissioner, no, he's Director.
No, yeah.
Yeah.
Commissioner Arnold.
Commissioner Arlinghouse. I get the
Commissioner
Commissioner's
Arlinghouse.
Director. I have a
Great.
question for him, and I just want to get it answered before I move it forward.
Let me know if I can help.
I
Okay.
will, thank you.
All right.
Okay, so we're on 482?
482.
Yep, 482. Okay.
I would just like to move ought to pass.
Second?
All right. Senator Carson moves ought to pass. Senator Gendro seconds. Senator Carson.
Mr. Chairman, I think it was made very clear how important it is for the National Guard to be able to get access to criminal history records. I know I was a little concerned to hear that the process isn't uniform across the state, and this will just make it a uniform process, so they can get those access to records.
Further discussion from the committee? Seeing none, all those in favor of ought to pass?
Aye.
Aye.
Any opposed?
Move consent.
Second?
Consent's moved and seconded, all in favor?
Aye.
Anybody volunteering to take this one out?
I will.
Senator Carson. Heard a 483 yet. Let's hold 484 because I want to talk with Senator Rosen a little bit more before I move that forward.
All right, did you just say 483 hold?
Well, we haven't heard it yet.
Okay. I'm just, okay. All right, so we're holding 484.
484 we're holding.
Hold, okay, 480.
485. Senator Carson
on the
has
list.
a motion.
Okay,
Okay.
485.
I would like to move ought to pass on Senate Bill 485.
Second?
Moved and seconded. Senator Carson.
Thank you, Mr. Chairman. I think this bill is right in line with a lot of the bills that we've filed about portability of licenses. I think military spouses run into difficulty just because they don't stay in one particular place for a long period of time. So what they really want to do is to utilize technology to digitize and streamline occupational and professional licensing for military spouses and veterans here in New Hampshire, just to make it easier for them. And as I said, it's right in line with a lot of the other issues that we've dealt with concerning portability of licenses, occupational licenses.
Further discussion from the committee?
Yes, Chair, if I could.
Yes.
485. So, I had a note here that, I think, I agree with everything Senator Carson just said, but I had a note that we wanted to make an amendment.
Regulatory authority?
Yes.
I had the same note and I was trying to remember it and I'm
And
up on line 14.
Yeah, so I had reached out to Director Courtney to see if we could get some language, and I don't know if I fully heard back, but.
Right,
Do you
I
have
also
anything
have
on
that.
this?
I'm not gonna claim to be an expert on all things right now, so.
Actually, yeah, I also have the same note
Okay.
with a question mark conflicts with OPLC. And in our discussions with Director Courtney, I think that she said if we were to change the language in line 14, part 4, every regulatory authority or licensing authority under this title shall adopt rules where applicable. Does that sound right?
So Doug, actually, there was a question
Yeah.
I remember about some licenses not being under, section 31 or section 30?
Yeah.
I'm trying
Title
to remember.
31, Title 30.
Title 31, I'm sorry.
Yeah, Title 30 licenses.
And this wouldn't impact all licenses, only the ones under Title 31.
That's right.
Is that correct?
I need to see the language before
Okay,
I can.
I'll tell you what, how about if, would you be okay if we hold
Nope,
this till next
we
week?
can-
And
yeah,
we
all
can
right, hold
maybe
this.
get these questions answered?
Yeah,
I-
she
I-
said here that it only applies to Title 30 boards.
Title
And not-
30 boards, okay,
Yeah,
yep.
not all OPLC boards are Title 30 boards.
Right.
So,
Right.
okay.
How about if we hold that then?
Okay.
Would you both be willing to withdraw your motion?
Yeah, fine. We'll just get some clarification.
Thank you, perhaps we can get this ironed out before next week.
Sorry, just to add one final piece to that conversation.
Sure.
I think that part of the issue might be that under 310 that we passed last year, under 310.17, that we shifted this rulemaking to the OPLC, not the boards. And that might have been why we were trying to.
317 has notwithstanding language, and it's about endorsement and reciprocity.
Yeah, okay.
So the office, that's substantially similar language.
Okay.
The office has the rulemaking authority around that.
Okay, we'll discuss offline.
All right.
Thank you.
I'll let you guys work that out then for next,
Okay.
You won't be here next week, so.
I will.
So perhaps you can defer with Senator Carson and Doug and see if we can
Yeah.
get that ironed out. Okay. All right, I have that on the hold list. Next will be 486, and that is the physician's licensure compact. I want to move that on to pass.
I'll second.
And for the very same reasons that I gave on the social worker compact, I think these compacts are important bills to help alleviate our worker shortage, and I would appreciate the committee's support.
I agree, Chairman.
Other comments from the committee? No discussion?
Let's do it.
All those in favor of ought to pass on Senate Bill 486, say aye.
Aye.
Any opposed?
Move consent.
Second?
Consent moved and seconded. All in favor?
Aye.
And I will take this one out too. Okay, I'm gonna hold 437. Senator Carson is still working on some issues on that.
487.
I'm sorry, 487.
487.
488, we do have an amendment for.
Chairman, just before we move on from
Yes.
487, I do have an amendment to that. I don't know if it's been released to the committee yet, so maybe I should just have Kevin pass that out so you guys can consider it with your amendment, Senator Carson, but it is just intended to capture that language from SB 75 last year that we worked together on.
Okay.
To incorporate it into the bill.
Well, I'll tell you, why don't you pass it around? If we get a minute to look at it, we
come back.
can, and we could come back to it. I've only got one more bill, but, so we'll sit on that a minute and give the committee an opportunity to look at it, perhaps before we adjourn for today. So 488 is, I want to move on to pass. Do we have a second?
Second.
And then I want to offer amendment 218S, should be in your folder. And this is an amendment that the interested parties who, we had a couple of concerns with the original language, and they worked on it and came out with this amendment. And I'm sorry, I'm trying to refresh myself on exactly what we changed here.
I'm looking at the two side by side.
You're just adding physician assistants.
Yeah, it was a technical
Yeah.
area where something was left out, and I'm trying to remember.
It looks like lines 3 through
Yes.
6, just a rewording.
Yes,
but-
I was
It
just
was
reviewing.
Mr. Osterhaus who gave the testimony.
Yeah, and Mr. Cuzzy was offered this simple fix. So
Okay.
between the two of them, they have crafted.
Okay.
You were involved in this, right? That's right. Anything you want to enlighten the committee on here? Or you're welcome to come up if there are. My apologies, I was trying to get my brain back in gear. We've moved through bills so quickly here.
I think it was a relatively easy fix. It's
Yeah.
really just clarification language and makes it fit into the statutes a little better.
Yes.
Didn't change anything.
That was my recollection too, but that seemed too simple.
Just
Occasionally it happens.
Yeah, just a quick question. So does moving, it looks like what we did was move the language around 328D from RSA 313A 25(3) to 1. Does that do something particular?
Sounds right. I don't have it in front of me.
Okay. All right. I don't have it in front of me either, but.
All right, further discussion on the amendment? Seeing none, all those in favor of adopting Amendment 218S, say aye.
Aye.
Any opposed? And we'll be voting on ought to pass as amended on Senate Bill 488 with Amendment 0218S. Any further discussion from the committee? Seeing none, all in favor?
Aye.
Any opposed?
Consent?
Second.
Consent's moved and seconded. All in favor?
Aye.
I can take this one out, or if somebody else wants to. I've got a few already, but,
I think it's good.
all right, I will take it out.
Okay. Mr. Chair, if we can, with Senator Perkins Coker's amendment, I'd like an opportunity to really read it and discuss with parties the amendment, if that's okay with everyone.
That is fine with me.
Okay.
Senator Perkins Coker, I know you won't be here next week, so I guess if there's, Senator Carson, if you have questions, we'll need to
I'll reach
confer with
out.
her beforehand.
I can get email.
Okay.
And maybe someone can be here to speak to it.
All right.
Okay.
520, I want to hold on that one. That is one we heard today, and that's the last bill I have on our sheet.
Chairman, I was just wondering, for 309, we've got some pretty heavy sponsors here. Is there something particular that was a concern for you to hold that one, or?
I don't think we've heard it yet, have
Yeah, we just heard it today.
Yeah, we
Oh,
heard
right.
it.
I just want to hold it. I'd like the opportunity to confer with leadership upstairs and make sure that everything's okay on this. I don't think there's an issue, but I know there also isn't a rush on pushing it through. I want to make sure that everyone is good with it, because personally, I didn't see an issue with it.
Okay.
But I'd like the opportunity to confer with others and make sure that we're okay with it.
All right.
All right.
Thank you.
With that, unless anything else that we need to know from the committee, I'll just say for the benefit of the committee, we have, I can't remember, Kevin, 5 or 6 bills on next week? 5. And there may be a 6 if I get it in time. And we've done a great job today on moving these bills through exec, so
Yeah.
we won't have a lot next week to exec.
Right.
Senator Perkins Coker, if there's something that you want us not to do next week in your absence, just please let me know, and we'll see if we can accommodate that, because I want to make sure you're involved as much as you want to be there.
Yeah,
I realize
thank
you have a conflict, so.
Yep.
Anything else before we adjourn? All right, with that, our work is done for today. We are adjourned. Thank you all.
Thank you. Thank you.